simply allow venues to move if they wanted to move to new, modern, refurbished, and quite often smaller premises. These photos here are the very first venue that relocated under the relocation provisions, the venue in Hamilton. The old Te Rapa Tavern was run down, unpleasant, unsavoury place to go. That venue was able to relocate and take its gaming machines with them. It was therefore commercially viable to spend over $3 million on a brand new sports bar, which is an absolute asset to the city. We should be encouraging these types of relocations and modernisations. That improves the local economy and it creates employment. Also encourages local tourism. Just like to share now the live example we currently have in front of Whangarei District Council. So Whangarei has got a relocation clause that's pretty much exactly the same as the one that you're looking to propose to adopt. Their relocation provision only allows you to move if it's circumstances beyond your control. And we've got a venue in Whangarei called the Tikipanga Tavern, which is in a high deprivation residential area. It wants to move from that area into the CBD, and the tavern's land wants to be used for a redevelopment, social housing. Now, there's been a negotiated deal done between the developer that wants to build the social housing and the Tikipanga Tavern owner, and the negotiated deal is, I'll take your tavern, I'll bowl it, you move it into the CBD, take your business into there. Our relocation application there was declined because it wasn't a circumstances beyond the control of the Tikipanga Tavern owner. So this is the current Tikipanga Tavern. This is the venue we would like to bold and build social houses. This is what's currently going on at the Tikipanga Tavern. This is what we would like to get away from and to move into the CBD, into a new, smaller, modern premise where there wouldn't be this sort of trouble. The venue, the Tikipanga Tavern, has had a number of armed robbery incidents and break-ins are common. We want to bowl this venue and turn it into this. But because this is going to be a negotiated deal, and it's not simply moving to new, modern, refurbished premises, it's a negotiated deal which is not beyond the fault of the operator. We're not allowed to move. And I'm just concerned that there might be similar cases in your district where large areas of land may be used for better purposes, and if we continue with this requirement that it must be due to an earthquake or a fire, something beyond the control of the operator, we may prevent fantastic facilities and developments like this taking place. It also seems odd to me that you'd want to remove the ability to move out of earthquake-prone buildings, particularly when you're close to the Wellington fault lines. This is clearly a health and safety issue. Why would council want to entrench venue staff and venue customers and premises that are potentially unsafe? The current policy that allows venues to move out of earthquake-prone buildings, it's a common policy that other councils have. It's perfectly reasonable. I can't see any logical reason as to why we should remove that option. Thank you, and welcome your questions.
Jared, thank you very much for providing that summary to what is contained in your detailed submission. And suffice to say, there's already been a question of officers raised from within. I'm not sure if you were listening online, but when we introduced the report, one of the questions to officers was the submission in relation to the relocation policy. So I think what I'll do is now invite questions from members of the committee in relation to your verbal submission and your written submission. So Councillor Allen.
Yes, thank you, and thank you for the submission. Look, when it comes to your urging us to consider the ability for these activities to relocate to brighter and more attractive areas out of the high deprivation areas, is it actually about that removal from high deprivation areas, or is it about those more attractive areas, therefore attracting more customers and with an end result of creating more problem gambling, because in effect there will be a greater participation in the activity?
Yeah, so the experience has been exactly the opposite. When we're looking at getting rid of the old school once were warriors type taverns where you and I would be fearful of going into without concern for our safety, those venues tend to be high revenue, high turnover venues. When you close those venues down and you move to a new modern sports bar, it attracts a different sort of clientele, and the new clientele doesn't tend to spend as much money on gaming machines. So when we see these moves to new modern premises, when we see venues go from the residential areas into the central business district, we actually see our revenue reduce by up to about 50%. So gambling customers aren't attracted to big, flashy, new, modern premises. In fact, the higher turnover venues are the venues that you'd probably want to put a bulldozer through.
And just for the record, supplementary, so the revenue with the new attractive venues, in your experience, has reduced by up to 50%. I heard you correctly?
That's correct.
Thank you. That's it, Madam Chair, from me.
Thank you, Councillor Allen. Mayor Wandin.
Thanks, Jared. Just a couple of sort of overarching questions regarding, you talk about the Gaming Association, Machine Association, representing the vast majority of the gaming machine societies. Can you just explain what that means? Do all venues need to belong to some organisation in terms of that? And you, by this, I'm sort of get the indication that you 75% or more you represent. Would that be a fair assumption?
So it's not the venues that belong; it's the gaming societies themselves. And there's only 2 or 3 gaming societies in New Zealand that don't belong. So the percentage that we represent would be over 95% of all gaming machine societies in New Zealand, certainly by machine numbers and certainly by revenue.
You also talk in your submission around the number of councils, and the number you mentioned is 55, that have not altered their relocation policy as far as you're aware. Have they gone through a submission process in terms of that as well? Most of them?
Yes, absolutely. Most relocation provisions now have either gone through 1 or 2 reviews. Their Hamilton City Council tried twice to amend their relocation provisions. Both provisions were unsuccessful. I go to every council meeting. No other council that I'm aware of has adopted a relocation provision and then looked to remove it or to restrict it considerably.
And has the earthquake-prone building, I mean, that's a relatively new issue in terms of certainly for someone like us in our position, has that been, sort of seen as a good way of the current policy being a good way to fit that into the current situation?
Well, having the ability to relocate out of earthquake-prone buildings, I would have thought would be absolutely essential, logical, and perfectly reasonable for your district. It's also a common provision in other policies as well. And I just can't think of any good policy reason why you'd want to remove that. All you're doing is entrenching venues in unsafe environments.
Thank you. Appreciate that.
Thank you. Just following up on that, because I think it's safe to say that within the committee, and we will deliberate on this, but there is some question about that health and safety and the concept of earthquake-prone buildings and how we might consider the wording of this clause of the policy. Your preference is that there's no change from the previous policy that was adopted in 2017, which was quite broad in terms of it talked about because the current venue is deemed to be earthquake prone, the lease has come to an end or it requires to move during public works, etc. And we've reduced that down to 3 potential reasons why a venue might relocate, being unfit to operate due to a natural disaster, Public Works Act, or the expiration of the venue's lease. The words you used were, I think you talked about beyond the control of the operator and in terms of health and safety under the Earthquake Prone Building Act. Is that something you'd like to see added as an additional clause, rather than just taking that existing clause out of the 2017 policy?
Yeah, so I think the existing clause is perfectly fine and should remain exactly as is. That expressly allows you to move out of a venue that's deemed to be earthquake prone, and there's plenty of registers that's available which can give you an earthquake rating to assess that. But also that the current policy expressly says if the venue wishes to relocate to a new or refurbished premise, which would be the situation like the Tikipanga Tavern, if you want to move out of a large block of land to a more central business district, and that's just simply a business decision that you want to make, and you want to free up the previous land for something like high density social housing, that would be an option that you'd be allowed to explore. You wouldn't have to wait to a fire or a flood, or wait to the buildings in such a state of disrepair that it's earthquake prone.
Okay, that answers my question. I think suffice to say that the panel have satisfied themselves with the questions they needed to ask you in response to your submission, and thank you very much for the submission made and the detail you've provided to back that up. We appreciate it. You're welcome to continue to watch live stream, but we'll be taking further submissions now, and we thank you very much for your attendance today, Jared.
Thank you.
Yeah, cheers. Okay, we're now welcoming our next speaker, who is Christy Kang from the Problem Gambling Foundation Group, I think is the correct title, PGF Group. Problem Gambling Foundation Group. Right, just making sure we've got your the title of your group. Christy, welcome. Welcome to this hearing for the Class 4 venue hearing today. I'm Jo Mason, Horowhenua District Council Deputy Mayor, Chair of the Hearings Committee. Mayor Wandin is on the panel today, as is Councillor David Allen. And I see you have someone else with you, but we've taken your submission as read, but we welcome your response today and your further oral submission. The Zoom is yours now.
Thank you very much. I'll just share screen. Cool. Tēnā koutou katoa. Thank you to the Mayor and the councillors for the opportunity to comment on the amendments being made to Horowhenua District Council's Class 4 gambling policy. My name is Christy Kang, and I'm the Manager of Policy and Public Health at PGF Group. I'm also joined by my colleague Gerhard Birking, who is the Public Health Lead of Mapamaya Pacific Services. A little bit about our service. Our services provide nationwide gambling harm minimisation and prevention services. We have counsellors based around the country, including Live-In, who provide face-to-face and remote counselling to those experiencing gambling harm. Firstly, we would like to commend Horowhenua District Council for having and retaining its sinking-led policy. The council plays an important role in ensuring the public health objectives of the Gambling Act are achieved. And by adopting a sinking-led policy, we appreciate that this council considers the health and well-being of the community to be of utmost importance. And evidence reveals that a sinking-led policy is one of the best policies available to reduce gambling harm and losses from gambling. Overall, we support the changes outlined in the statement of proposal. And while it is our view that allowing for relocation undermine the efficacy of a sinking lid, the proposed changes, however, are restrictive, and it indicates the council's commitment to further reduce the number of gaming machines in Horowhenua. And we believe that this is a step in the right direction. We advocate for a more restrictive Class 4 gambling policy because not all gambling is the same. Class 4 gambling, or pokies in pubs, clubs, and TABs, is characterised as high risk, high turnover gambling. and the Ministry of Health has identified Class 4 gambling as the most harmful form of gambling in New Zealand. It is important to remember that pokies are highly addictive, and they have been specifically designed to be very absorbing and encourage people to participate in continuous gambling. One of the reasons that make Class 4 gambling so harmful is because of the location of poker machines in our communities. More than 60% of all Class 4 poker machines are located in the most deprived communities in New Zealand. And the DIA data shows that as at 30th of September 2021, all 8 Class 4 gambling venues in Horowhenua are located in very high deprivation areas. It is unethical that the majority of Class 4 expenditure is coming from our lowest income households who can least afford it. This is particularly concerning given that this disproportionately impacts Māori and Pacific peoples who generally live in these areas where they are highly situated. Now I'll pass on to my colleague Gerhard.
Nā koutou katoa, talo whalawa. My name is Gerhard Birking and I am the Public Health Lead for Mapamaya Services, which is the Pacific arm of PGF Group. When looking at Pacific and the Pacific peoples in the Horowhenua district, we make up around 5.7% of the region's population. When looking at Levin, however, who houses 7 of the 8 Class 4 venues, Pasifika people make up roughly 10%. And so there's a high representation of Pacific in Levin specifically. Relatively high access of Class 4 gambling in areas where there is high representation of Pacific is not just a trend we find in Horowhenua, but it's a trend we see across the country as well. We find that this is a problem as we continue to be relatively high in harm compared with the rest of the country. We currently have a counsellor who works in Levin part-time, and she has been placed part-time in Levin and since 2019, I believe, to respond to the need for support around problem gambling for Pacific families. And she's been working directly with families who have been experiencing harm, not just the gambler, but partners, children, and extended members of the family. And alongside the financial harm that presents, our people also have been dealing with the social harms that follow and breakdown within the family, conflict, etc. It's our position that should our higher deprivation areas in the country be saturated in this product, people will turn to it and gamble out of need, subsequently causing more harm to themselves, as seen in statistics around problem gambling. The 2018 Health and Lifestyle Survey shows that Pacific people were 1.5 times more likely to be moderate risk or problem gamblers than non-Pacific peoples. With Māori, it's even higher, 4 times more likely to be moderate risk or problem gamblers than non-Māori. And they also make up a 25% of Horowhenua, the population. Pasifika, we experience harmful gambling differently. Typically, we are a collective peoples, and anecdotally, our counsellors have shared the trend of Class 4 gambling, when harmful, has placed our members of the family, our Pacific members of their families, into silos and removed them away from important protective factors to their health and family, and also important cultural spaces. Even though we provide therapy and counselling for those in need, the exposure to Class 4 gambling remains a struggle for our clients throughout. One step forward counsel to protect the health and well-being of vulnerable communities such as ours is to regulate where venues can be established and put in place measures that will restrict the growth of Class 4 gambling in the district. In closing, Mapamaya and PGF Group support the proposed changes as they are more restrictive policies in regards to relocation and club mergers. Thank you very much.
Thank you very much, Kirsty and Gerhard. Much appreciated you speaking to your submission. I will now ask Councillor Allen and Mayor Wandin if they have questions for. Are you both happy to take questions?
Sure.
Yes, they are. We're going to start with Councillor Allen. Councillor Allen.
Yeah, look, thank you both very much for your submission and the clarity of it. Did you hear the verbal submission Jared made just prior to you on the on behalf of the Gaming Machine Association?
No, we haven't, but we often do meet them on the council front. So I think I expect what kind of submission they've provided.
Have you read the submission then that was given to us?
Yes.
You have. Thank you. Okay. So look, in addition to the written submission, Jared identified a strong belief on behalf of the association that the policy should include the ability to relocate to lower deprivation areas, and he produced some arguments around that, including he identified that where that has happened, revenue has in fact reduced, sometimes up to 50%. In light of that, and looking at in terms of our order paper, I'm not sure of the number on your submission page, but our order paper, page 59, your paragraphs 16 to 25, you identified there and in fact spoke to it that there are real risks in having gaming machines in the high deprivation areas. So in light of that, I'm just wondering why you are not supporting, or would you like to support, the Gambling Machine Association's suggestion that the policy should be amended to allow these pokies to be relocated in the lower deprivation areas?
That's an interesting with relocation policies, that is an interesting point because it does allow for the opportunity to move pokie venues from high dep to low deprivation areas. But in reality, we don't see that happening a lot of the cases, mainly because high deprivation areas generates a lot of revenue or losses. So it doesn't really happen a lot in those situations. And it's our view that relocation policies shifts the problem to another place. So just because you move a venue from high deprivation to low deprivation, it doesn't mean it's not affecting the community in the same way. And nothing is preventing people from those high deprivation areas going to the low deprivation venue to gamble. So it just shifts the problem to another region, basically.
So supplementary, Madam Chair?
Yes, absolutely, Councillor Allen.
Thank you. So if it is simply shifting the problem to somewhere else, that suggests it's not making the problem better or worse, it's shifting it. So in that sense, A, it's neutral, but B, the claim from the Gambling Machine Association, because I asked him to repeat his claim, is that it actually does reduce the income, the revenue from gambling. And he said in some cases up to 50%. So these are important matters, surely, that the committee must consider. This is a pretty key area. And I guess I just still have to reiterate, in light of those claims, and unless you can identify evidence to the contrary, why would you not support the ability to relocate to lower deprivation areas?
I might just add, because the purpose of a sinking lid policy is to gradually reduce the number of poker machines in a community, but allowing for relocations maintains that number. So if we do allow for relocations, whether it's areas, it doesn't really address the problem of removing poker machines from a community area. So even though it reduces by 50%, I don't know where they got the figures from. Again, it is still a considerable amount of money coming from people in the community.
So my final question, Madam Chair.
Yes, absolutely.
Thank you. So that brings me to my next concern, and I'm referring to on the order paper, page 61, it's paragraph 34, where you say there should actually be no relocations because it undermines the sinking lid policy, which is something you've identified here. And yet you have endorsed the current relocation policies in your submission. Do you wish to address that?
Yeah, it is quite paradoxical because we do advocate for a true sinking lid where there's no relocations or club mergers allow. However, we do recognise the council's position regarding the difficulty, because if, for example, an earthquake were to happen, it is out of the scope of the council. So we do understand why it happens, and that's why we do think it's okay in a way. However, with this proposed amendment, it is far more restrictive than the current, what is outlined in the current policy from 2017. And we do think it is, a step in the right direction towards a true sinking lid, but we understand the restrictions that council might be experienced with the gambling industry regarding the necessity of relocations and club mergers.
Thank you, and thank you, Madam Chair.
Thanks, Councillor Allen. Mayor Wandin.
Thank you, Chair. Christy Gerhard, thank you for your submission. Look, just a couple of things around those deprivation areas, because it would be my thinking that the whole of Horowhenua has a deprivation challenge, and we are in that 9 or 10 space anyway. The fact that we have especially the locations in Levin are all with close proximity to the main thoroughfare. They are all in the CBD, if you like, stretching over maybe a 2 kilometre space would tend to indicate to me that they are in the right positions, even though they are in a high deprivation area. That in fact moving them would actually cause more problems than they do currently. Would you agree with that assumption?
No, because there's no evidence that suggests that. The Ministry of Health reports from and studies from the Ministry of Health does show that high deprivation areas are where the harm is greatest. So essentially what is happening in Levin is there's a gambling hub and it's more accessible. And realistically, in a public health perspective, if there's harmful products in an area, it would make sense to remove it in terms of health and well-being of the community.
So I suppose market forces would then dictate whether they're going to be successful or not. If their primary purpose is not to provide gaming machines, then they've got to sort of still exist in a commercial way for them to be successful. And I would have thought, and that's where I think our sinking lid policy is achieving what it set out to do, because it is forcing those venues to make sure that they are viable through other means rather than the gaming machines.
Mm-hmm. And I should note that under the, I believe it's the Alcohol and Sale and Supply Act, the primary purpose of a venue can't be gambling, and income shouldn't solely be from gambling as well.
The other, in your submission, you talk about there being 4 main types of gambling modes. Do you have a sense of in locality in terms of the breakdown of that sort of those modes? I mean, the amount of money that's spent on electronic gaming machines higher here than, say, Lotto? It would obviously be casino and TOB, but do you get a sense for that sort of data at all?
We would have to check with the Ministry of Health. I'm not too sure about the locality specifically for Horowhenua. However, in terms of the client intervention numbers or the number of clients the Ministry of Health supports through our services such as ourselves, almost half is for Class 4 gambling. And then it's, Gerhard, maybe if you remember, I believe it's Class 4 gambling is the highest. And then to a lesser degree, lotto, TAB, and casinos. But class 4 is the one that's causing the most harm in terms of client numbers.
Yes, I can. Well, we did an extraction of our PGF group data between 2010 and 2019 to show that yes, over half of our clients were there because of class 4, and with Pacific around, it was about a 50-50 split of gambler to affected other as well. Just to highlight how gambling is also not just affecting the gambler, but going further out and affecting family members too.
Thank you. Just to follow up in terms of the numbers of problem gamblers that we may have in the district, the public health unit has some data that says that 29 to 59 clients may be problem gamblers in the Horowhenua. And I wondered whether you have any sense of whether your councillors have that sort of view, and in terms of the breakdown, is it mainly Maori and Pacifica that we have the issues with?
I'm not too sure about the ethnic breakdown, but I do believe because we have a counsellor, or Mapamai has a counsellor based on the VIN, part of our clients might be included in that one. But I should just note that in terms of presentation to services such as ourselves, the Ministry of Health estimates that only 16% of people who experience gambling harm do seek services and support. So there's a huge barrier of shame and stigma. So just because they're not coming to services doesn't mean that there is no gambling harm in the community. Gerhard, do you have anything to say regarding the distribution?
No, I was just going to second what you said, and I don't have the exact figures around our counsellor's caseload in the area, but I do know that she works to capacity about 3 days a fortnight, and so that's all I can share. Sorry.
That's fine. Thank you very much. Appreciate that. Thank you.
Thank you, Mayor Wandren and Councillor Allen. I just had a couple of follow-up questions. And thank you for your submission. And obviously, as a committee, we need to make recommendations to our full council as to whether we think the proposed policy is adequate or we need to change wording. I'm just wondering, we've got the relocation policy there that as Councillor Allen alluded to, we've had submissions from within the Gaming Association to revert to the relocation policy of the 2017 policy. However, we've included we've got a clause in number 5 under 5.2 of our proposed policy that talks about the restrictions on where a venue can be relocated to, and it talks about under number 5, any new Class 4 venue, temporary permanent, will not be located closer than 150 metres, and talks about schools, childcares. One of the things that I'm considering proposing under deliberations is to consider that the wording that's used for our local alcohol policy, which is even more restrictive, includes marae, hospitals and things like that, is included in that. Would that go some way to comforting you about the relocation policy that we're proposing provides sufficient guidance and restriction of where venues can be?
Yes, I think the more restrictive it is, the better, and especially for communities like Māori and Pacific, perhaps putting that restriction around and places of worship, where community centres might be a good idea. Again, we do advocate for a sinking lid with no relocations or mergers, but we do understand the predicament that places to council. However, a more restrictive one would be in our favour.
Thank you. I did some quick maths around the venue merger part of the policy, and it talks about that I think previously we had no more than 30 machines. In this instance, that if we adopt this policy, it can be no more than 2/3 of the total combined machines that would again support our sinking lid policy. What it could potentially mean though is that a combined venue could have 24 machines, whereas the maximum machines in any one of our venues at the moment is 18. Do you have any comment on that?
Yeah, that's the tricky part with club mergers. Club mergers under the Gambling Act allows up to 30, but what we describe those 30 as a gambling den, essentially. So even though clubs can merge, we do think 24 is still a lot. I mean, 18 is per the 2001 amendment. So currently new venues, if they were to be established, only 9 can be installed. So 24 is still a lot. However, again, this policy, this amendment is more restrictive. So it is 24 is way less than 30. So it is argued that it is more restrictive. So it is better of the other option.
Thank you. I think both yourself and Gerhard have responded to all the questions that we had of you, and we appreciate that. The only thing that I will refer to quite briefly and alert my colleagues is that under your submission recommendations, number 36, you have referred to an item that we haven't accepted onto the table. It's report 5.2 in terms of the TAB venue policy. And you have, I'm just not sure if you're planning to stay for the whole hearing or if you want me to address this now or you want to be heard in relation to the TAB venue, or is it just that you wanted to note your support for removing reference to the Racing Act 2003?
Yes, noted for that one, please.
Okay, so you don't need to speak to that?
No.
Okay, great. Gerhard and Kirsty, thank you so much for your submission, for speaking today and being available to us to answer the questions. No doubt you will follow closely to see what we resolve in terms of our recommendation to Council, but appreciate your input to our hearing today. Go well.
Thank you for having us.
Thank you, members of the committee. We've now completed the verbal submissions for today, but I think it's appropriate to turn to back to the officer's report, which summarises all of the submissions we've received, because there are an additional 6 submissions that haven't had speakers, but that we will need to consider under deliberations. But I just want to open up again to members of the committee if there are any additional questions that have emerged for the officer of the report following on from the verbal submissions, or anything in terms of written submissions that are before us.
Just Madam Chair, the Mid-Central Public Health were identified as speaking to their submission.
And apologies for not updating you at the beginning. I think that was done before we got onto Zoom. At Central DHB have unfortunately had to withdraw from speaking. They have other priorities that they have to attend to today, and have requested that we consider their written submission on this matter.
Okay. All right. Thank you.
So are there any questions now for the council officer to the report in relation to what's in the report or any of the submissions? Yep.
Madam Chair.
Go, Councillor Allen.
Oh, thank you. It's been a while since I've been involved in a hearing, but the question I've always used to ask was, having heard the verbal submissions, does Vi want to make any recommendation or as to changes in the proposed policy from an officer point of view?
Thank you, Councillor Allen. No, I don't wish to make any changes to the recommendations. However, I do think that there has been some submissions presented this afternoon that I think do need consideration by councillors around making some potential changes to the policy that was presented.
Thank you.
Just bear with me while I work out where we are in terms of. Okay, we will. I think perhaps what we'll do now is go into discussion of the report and discussion of the submissions, and after which, if we come up with any recommended changes prior to adopting 3.4 and 3.5 on the report. So happy to move into discussion in terms of written, verbal submissions and the policy that sits before us. Anyone wish to start? Alan, Councillor Allen.
Well, thank you, Madam Chair. Look, having listened to the submissions, well, first of all, speaking to the report generally, I'm comfortable with the general thrust of the draft report. I think it's a continuation of an affirmation of our belief in the sinking lid policy, and in fact, there's been very little challenge to that as a policy. On the particular issue of the relocation criteria, there has not really been any challenges, including from those parties who really don't think there should be the ability to relocate at all, even though they on the one hand said that, on the other hand they said we understand council's position and so we don't object to the three already identified, which is the natural disaster, the public works and the expiration of the current lease. The two that I'd really like us to consider is, first of all, the moving to a higher earthquake rating building. And to me, that is a health and safety issue, and I can't really see that we are doing any justice to anyone by refusing an application to move to safer premises. So I would speak in support of that. And the second one, which really intrigues me, because until I heard the discussion, I was really dubious about, is the ability to relocate to lower deprivation areas. And look, I'll be honest, I thought it was about increasing revenue. I'll be quite honest. That's what it sounded like to me. The evidence that was presented today by the Problem Gambling Foundation and was not challenged, because I really wanted that question to be addressed by, not by the Problem Gambling Foundation, but by the Gaming Machine Association. And the Problem Gambling Foundation really did not challenge that. So again, the claim was made that it's actually neutral or can actually reduce the income. So I guess for me, it's about listening to the evidence presented on the day, and if there's no challenge to that evidence, then it seems to me that I for one would not want to block that as a clause also, the ability to relocate to lower deprivation areas. So that's where I sit, Madam Chair, which is to maybe have a bit of a chat about adding two more criteria in terms of relocation.
Thanks, Councillor Allen. I guess I go to the fact that the submissions have encouraged us, or for those who oppose the removing of the relocation policy 0.5 of the 2017 document, that they want us to retain that statement as is, whereas we've reworded it and have a series of explanations of what where a venue could move through no fault of their own. So is it that we revert to the original policy, or that we add a high earthquake rated building, I'm just wondering which is the best way to deal with it. And because one of the submitters, the submitter for the Gaming Association talked about circumstances beyond the control of the operator, I don't know if that's tight enough. Your second one was, so yours was higher earthquake rated buildings or moving to a lower deprivation area.
Yeah, correct.
Okay. And I'm wondering about the concept of circumstances beyond the operator's control and wonder what they might be or what might make that an acceptable clause. Is there any commentary on that?
Well, personal view is that it's too broad, that we need to identify the very specific reasons for which they can relocate.
I have a slightly different view. I do believe the policy needs to retain some sort of flexibility, and that we've seen even in these last couple of years while this policy, that the earthquake-prone building changes have indicated that there does need to be some consideration for those venues that need to move because it is out of their control. And I think that there may well be other situations, whether it be a pandemic or whether it be some sort of other situation that is out of the venue's control, that they do need to move, that we should at least give them some sort of degree of, at least we'll look at it. There are, I believe, a number of other compliance requirements in terms of where they can situate that would give me comfort in terms of that they just can't go anywhere anyway. I also think that it would need to be some sort of deliberation around whether that is appropriate at the time. And that over the next 3 years, who knows how life may change around things. I'm also comforted by the sinking lid policy is working. We have seen a considerable drop in the number of gaming machines in this district over the last few years, yet our problem gambling numbers seem to have plateaued, according to their stats. So it's not necessarily reducing the gaming machines that will have an impact on our gaming problem, if you like, or our gambling problem. The other issue is that in terms of deprivation, this whole district is a deprivation level of 9 or 10. So they can't really go to a lower deprivation level unless they go out in the middle of Ohau or probably something like that, which would be totally inappropriate for because of other reasons. So I don't think we actually need to actually specify even that as a reason for going, because I still believe there are other issues that we need to consider before we would allow such a move to happen anyway. So I do think there needs to be some sort of flexibility in that relocation policy, and pretty much agree with the Gaming Machine Society in terms of that. I think gaming machines are pretty heavily controlled, despite the amount of money they take, and also acknowledge, while it may seem small in the big scheme of things in terms of the amount of money they're taking, what is coming back to the community is enabling those groups to sustain themselves and still be viable. So yeah, I'm leaning the other way, if you like, Alan. David, sorry.
Just in response, Madam Chair.
Absolutely.
Yeah. No, look, I very sound points, Your Worship. Just a question maybe to Vi. If the wording were to be circumstances out of the operator's control, how would that work in reality? How would that be processed?
I think that's a really fair question, and it's probably one we need a response from officers, because if we're going to recommend wording, it has to be wording that doesn't place officers in a difficult or subjective situation. So we'll take advice from Vi on this.
Thank you. My advice would be to steer away from broad statements as much as possible. It is a policy to provide the guidance for, the rules essentially for officers to be able to apply in these circumstances. So the broader it is, the more difficult it is, and the more subjective it becomes to each officer. Having said that, if we did have a broad statement and a policy, it would require us to develop some policy guidelines around how we do apply that statement, and we would require some guidance from councillors in terms of this decision-making process as to how that should apply.
So the discussion at the moment talks about considering point D, which is to move to a higher earthquake rated building, or words appropriate. And I wonder if E could be a new refurbished premises that complies with all other conditions of this policy. So therefore they have to meet the requirements of no additional machines, all of the compliance around gaming operation. It would have to meet compliance in terms of being a licensed refreshment venue, that whatever we agree in point 5 of venue location in terms of where it can be in relation to marae, school, hospitals, etc., would have to be complied with, so that we're not restricting venues from moving, but it has to be that any relocation complies fully with the intent of this policy and the conditions of this policy, or the guidelines of this policy.
Can I just then put a hypothetical then, that if the compliance department decided that a building was dangerous or unhealthy, the people operating the machines don't own the building, but agree with that assumption that it is dangerous, they are therefore not allowed to relocate. Is that what, that to me, that doesn't give that flexibility in terms of that policy, doesn't give that flexibility in being able to take into consideration those sorts of things. And that's why where I'm seeking some sort of, I know I can understand where you're coming from in terms of the policy needs to be definite, and so that there's no sort of, if you like, trying to change the meaning of what you're trying to say. If they had lawyers or whatever, it leaves it open. But in terms of, there is generally a situation where the policy can be too restrictive.
Did you have a response to that?
Yes. So I guess it comes down to the enforcement of the policy. So at a point of time, an application may come in for officers to need to determine whether or not it meets the policy criteria. What I would urge for the decision makers to do is to provide enough clarification around when the policy applies versus doesn't. So if there is a way to strike a balance as to being enabling in circumstances such as that, then by all means.
So, Mayor Wandin, you referred to, I just want to be clear, if the building was deemed to be unfit to inhabit, so can that be included in the wording of clause A?
If it doesn't fit council's health and safety compliance, as well, type of thing, or if there's, some sort of, and that could then cover the earthquake prone situation as well.
Councillor Allen.
Look, this is a good contest of battle of wits here, Mayor Wandin. I'm still on the other side of the fence. I'd rather that we erred on the side of being too restrictive but being specific than to open things up through broader language. the only way I can see practically where Mayor Wandon's approach could work would be where, as Vi says, we develop very careful policy statements and criteria by which we can judge these cases. And furthermore, to be super safe, I would suggest, if we go that way, that those cases be brought to a meeting of the hearings committee, because I think it would be a very tough call on officers if we do have such a policy, particularly in the early days and the implementation of that policy. I think we're just from a global point of view, where I'm coming from is I fully support, and the submissions also fully support, a robust sinking lid policy. It's working. The relocation policy, the 3 clauses at the moment continue along exactly the same value set. It's about very strict criteria by which they can relocate. So it sits under a very strong message about a sinking lid policy, very strict reasons only for relocating. And at this stage, the only addition I would personally want to make would be a D, and that would be about higher earthquake ratings. If you start to open up under other health and safety things, I just think we're going down a very difficult path in terms of implementation. So that's a personal view.
Yeah, look, I do tend to agree with that now, David. The other thing that gives me some comfort is that this policy is only going to be needed to be reviewed in 3 years' time. We've not had any relocation applications in the last 5 years, so I'm comforted by that sort of approach. Definitely, yeah, at this stage. In consideration, the policy does need to be more definite in terms of its requirements, and not open to, if you like, interpretation from different outside, because they will not get that interpretation. It'll be a different interpretation for what we mean it to be. I can understand where you're coming from in that, and where Vi is also coming from in that space.
So what I'm hearing is that there is no appetite to revert to the former policy that talks about another venue or rebuilt premise for the same number of gaming machines. That relocation is only for the purposes listed there, A, B and C, as in the proposed policy, and with an addition of D, a higher earthquake rated building. Or an earthquake, a building that meets earthquake rated standards.
Higher earthquake rating. Earthquake rating. Yeah.
So that's the only addition that we're seeing as required, but that every change in building would still be required to meet the clauses of 5.2.
Mm.
Can I have an officer comment on that in terms of suggested wording?
Yes, absolutely. So I do agree. If a premises is moving out of a venue into a new venue of a higher earthquake-prone National Building Standard percentage, it's called NBS percentage.
Councillor Allen, are you happy with that recommendation that speaks to a building with a higher NBS percentage that meets that, Mayor Wandon?
As long as they're not moving, it's still above the 34%, lowest rating that is publicly available. That's fine. If they're going from 15 to 25, then that's not really a...
Yeah.
So our direction to officers is to include under 5.1D that moving to, or words that cover off the intent that we're signalling, moving to a building that meets or exceeds NBS percentage earthquake rating.
Yes.
Is everybody happy with that as as a recommendation?
Happy to move.
Yep, I'll second.
Thank you. All those in favour? Aye.
Aye.
Okay. The next one that I want to move to is one that I did circulate with the hearings committee prior to this meeting, was in terms of considering consistency. Council last year, I think it was, adopted local alcohol policy that spoke to that I wanted to align with, as I said, for consistency with 5.25 that speaks to or strengthens the location of where a new venue, either temporary or permanent, can be or actually cannot be located closer to. And I did circulate to members of the committee 7.2 of the local alcohol policy. I don't know if you all received that by email this morning, but that clause 7.2b refers to no new on licences shall be issued for any premises located within 100 metres of the legal site boundary of any school, early childcare facility, place of worship, marae, healthcare facility, public car park or reserve, urupa or cemetery existing at the time of the licence application is made. There may be some parts of that clause that are too restrictive, but I did think that given the submissions from the Problem Gambling Foundation, we maybe needed to consider some more restrictions under number 5 in terms of considering healthcare facilities and marae in that, and I'd be interested in hearing the views of the committee on that. Councillor Allen?
Yeah, just a question through you to Vi. From an officer perspective, do you see any problems or issues with that?
Thank you, Councillor Allen. I don't see there to be any issues as such. However, in the current draft, it does have "and other community facilities," whereas in the local alcohol policy, it is very prescriptive around the types of facilities. So I would encourage that we consider having a more, in this case, a broad term around community facilities for those facilities accessible by the public.
What can I just? Did you have a supplementary, Councillor Allen, before I?
No,
my question?
all good.
Okay. So what problems is that likely to throw up for officers if we leave, if, as you advise, we leave that as broadly as community facilities?
So this is a bit more easily defined in relation to community facilities. So they are accessible by the public or community groups.
So that would include healthcare facilities, marae, public parks and reserves, urupa or cemeteries. So would they be covered off by that broad language, and could they be covered in this policy wording as it exists?
Yes, I believe so. Yes, it would be covered in the other community facilities. I don't see there being a risk as such by adding those into the policy, but would encourage that we also retain the other community facilities as well.
Okay, so we could include the wording but leave the addition of any other community facilities. And my understanding is that because Class 4 gaming machines have to be operated within a licensed premises that primarily focuses on serving refreshments, that no license could be issued unless it was, and no new licenses can be issued anyway. But if someone was looking to relocate, that these restrictions would be adequate guidance for officers.
Yes, that's correct.
So can I just have an indication from the committee as to whether they feel strengthening this number 5 with the addition of the wording that sits within the local alcohol policy and retaining "and other community facilities" is necessary, or if there's a sense that clause 5 as it exists is adequate? Councillor Allen.
Yeah, well, I support it without the phrase community facilities, I think, and I appreciate where you're coming from, Madam Chair, in terms of strengthening it. So with the deletion of the community facilities thing, phrase.
We wouldn't delete it, we would add the other words and include other community facilities to allow officers to consider.
Oh,
any-
sorry, yeah. No,
Any
sorry.
community
With the-
facilities.
Yeah, no.
Okay. Mayor Wandin.
Yeah, comfortable with that approach.
So the recommendation is that clause 5 reflects the reference to all of the noted facilities within clause 7.2b, the local alcohol policy, but retains the wording and other community facilities.
Yep, happy with that.
Okay. So moved Councillor Allen, seconded Mayor Wandin. All those in favour?
Aye.
Okay. Is there anything else in terms of the recommendations for the proposed gambling class 4 venue facility that you would like to discuss, consider, or additional changes required based on submissions or discussion today? Councillor Allen?
No, I'm fine, thank you.
I am also fine, thank you.
Okay. So I think that we have sufficiently considered and deliberated, and I just want to acknowledge the committee for clearly the work that's been done in terms of reading and understanding what's before us, taking into account and showing a good understanding. It's refreshing. I appreciate the contributions on this report. So it puts us to move 3.4 and 3.5 with the amendments that we have agreed, what go to council for adoption, for recommendation for adoption. So is somebody happy to move 3.4, that we've considered in the submissions and recommended changes, and that we recommend to council the adoption of this venue to repeal the 2017 policy, 3.4, 3.5. Councillor Allen? You're moving? Thank you.
Yes, happy to.
Mayor Wandin?
Yes.
Second, all those in favour? Aye.
Aye.
Thank you. That brings us to the end of report 5.1. We now move on to report 5.2. That is on page 73 of the agenda. And I'd just like someone to move that we receive 5.2 TAB venue policy considerations and submissions. Mayor Wandin. Councillor Allen, thank you. All those in favour? Aye. Carried. Okay, this may be more straightforward. Just
Not if I have anything to do with it.
Just to introduce the report, that we have a recommendation here that there is wording changes that recommend changes in the law in relation to the racing TAB venues, and those are spelt out and were supported by one of the submissions. But I would now like, we've got the discussion and councillors and officers considerations. I'd now hand over to Vi to provide any additional commentary to the report that she's got before us before we take questions.
Thank you, Madam Chair. So there has been no proposed changes to the TAB venue policy from the previous 2017 policy, other than to update the policy to remove the previous legislation to now the Racing Industry Act 2020. We currently don't have any standalone TAB venues in the district, and the policy proposal recommends that we retain the position of the opportunity to have one standalone TAB policy, TAB venue open within the district.
Thank you, Vi. And we do have two submissions, none speaking to this, but both written submissions. One was from the Problem Gambling Association supporting the wording to reflect the legislation changed, and the other is a written submission from the operator of the Live-In TAB. But Mayor Wandin had a question.
Just a question, Vi. In terms of, say, another licensed premises requesting a TAB on their premises, is that decided by the TAB, or do we have an opportunity to actually decide that?
So I guess that question's in two parts. Any alcohol licensing requirements, we would apply the local alcohol policy, and it would need to go through the council processes, regulatory framework around that. The second part of the question is around the venue and the gaming machines, not gaming machines, the TAB operation. The difference between, I guess, the pub or club that you might see now with the TAB self-service machines that they have there, that is not considered a standalone. The standalone is where it's actually occupied and run by the TAB. Yeah.
Well, my question is more about, say, if the Oxford decided that they wanted a TAB within their premises and those machines, whose decision is that?
So it wouldn't then be a standalone. So the standalone is it's run by the TAB, not by the Oxford. So the Oxford itself, in order to have the TAB, slot machines and that sort of thing in it, they can have it as part of the self-service, but it wouldn't be a standalone. They wouldn't need to apply. So this policy doesn't apply to any of the self-service machines. Yeah.
Did you have any questions, Councillor Allen?
No, I'm fine, thank you.
Okay. I just want to, while we're in the discussion phase, having received the report before we consider the recommendations, turn to the submission that was written. Are there any comments or any consideration that they are considering that we should offer TABs more broadly than Live-In, that we should have more provision for more than one, is my read of that submission. However, the policy is saying one, and that one exists in Live-In. Is there any other commentary around the submission that we've received?
Well, there's not a question from me, just a comment that I disagree with the submitter.
I concur.
And I concur as well. So,
Councillor Allen, that is.
yeah, it's Councillor Allen, it's mine as well. So, that said, is there any other discussion, consideration, questions in terms of either the report or the submissions before we move on to the recommendations? No? Okay. So we've received the report. We've now got 3.2, 3.3, 3.4 and 3.5 that I recommend we take in block. Is there any objection to that? No? Somebody like to move? Is that you, Councillor Allen?
Happy to move, yep.
Happy to second.
Thank you. All those in favour?
Aye.
Aye.
So moved, and so that recommendation is that we recommend to Council that the amended TAB venue policy be adopted. That, committee members, brings us to the end of the hearing and the end of this meeting. Is there anything from officers that you needed?
No, just at the next stage we'll be presenting the findings of the hearings committee and the recommendations through to the next council meeting. Once on the agenda.
Okay, and as chair, I'll undertake to check that the recommendations that go forward reflect the intention of the committee today. If you're happy with that. Okay, so I'd like to thank you all for your attendance. Thank you to anybody who has Zoomed in for this meeting, watching live stream, to submitters, both written and oral, members of the committee, members of staff who are here today, and that brings us to the end of the hearing. Kia ora tātou, everybody. Have a good rest of your day.
Thank you, Madam Chair.